Our first matter is set for 115. It's 114. It's entitled Southwest Michigan Asset Management Company versus Michael Cripps. Mr. Cripps is a resident at 403 Center Street, and that property was subject to a sheriff's foreclosure sale in July. Mr. Stephen Smith is here for the plaintiff, and Savannah Miller is here on behalf of Mr. Cripps. If I understand correctly, Ms. Miller, Mr. Cripps is in the hospital?
Yeah, he is having issues with his suprapubic catheter. I was actually headed back down there right now. I just left my home to head back down there.
He's in the hospital where?
At Sturgis.
Since when?
I took him about an hour ago because his suprapubic fell out.
What tube?
His suprapubic catheter.
Oh, okay.
The catheter that goes into your gut. Sorry.
All right. Well, has he made any, now, do you have any power of attorney or anything, or are you just a friend?
I do have power of attorney. It was notarized by the courts there in Centerville.
Has he made any plan to move?
I was asking if we're in the process of obtaining a lawyer for this. I was asking if we could push this hearing out for maybe like a week or so. With Mitchell's health and stuff, it's been kind of a pain to get an attorney. But it's kind of the property, it's kind of a mess, and we want to speak to an attorney before we do anything.
All right, well, that's certainly, you're right. Now, this is a foreclosure action. So this was years in the making. So he hasn't made payments in quite some time. They told him they were going to do a sheriff's sale. They did a sheriff's sale on July 10th. He has 180 days from that day to vacate or is subject to being evicted. And he's still there, so they want him to move out. I'm not sure what his defense is. Maybe there's something that I'm not aware of.
Yeah, so what happened was before that sheriff's sale, we had signed paperwork with a different.
You're breaking up. I can't hear you very well.
Can you hear me better?
Go ahead. Yes.
Okay, sorry about that. So in June of 2025, before the sheriff's sale,
I can't hear you. I can't hear you.
Can I call in?
Well, let me see if I can turn off your camera. Maybe that might get a more. Here's Meg Bauer from Legal Aid. Anyway, your request to adjourn is certainly acceptable.
Yeah.
Started.
No.
Hello.
Hello. Mr. Smith, how about if we go 10 days? Are you available on Monday, the 16th at 2:15?
I could do that. Yeah.
All right, Miss Miller, you have power of attorney, but you aren't his attorney, so you can't actually represent him. Meg Bauer is here from Legal Aid, and I could put you in a breakout room where you could talk to her, but your phone doesn't, we can't hear you. So my suggestion is that you call legal aid later this afternoon and seek some legal counsel from them. But this is a fairly straightforward process. The mortgage goes unpaid for several years. The company starts the foreclosure action. Several months pass, they have a sheriff's sale. Then the defendant has 180 days after the sheriff's sale to redeem. If they don't redeem, they move to foreclose on the property. And that's what's going on here. So they want him to move out. And so do you have something to write with? I've got a very bad connection with her, Meg, and I couldn't hear her, and now her screen's locked. Miss Miller, do you have something to write with? The defendant, Mr. Cripps, is in the hospital. She's on the way to the hospital to see him. So I don't like really doing this by the car, but Miss Miller, do you have something to write with? All right, Meg, why don't you give her your phone number?
Yeah, thank you, Judge. Ms. Miller, you can contact our intake line at 269-344-8113. And the sooner you do that, the better.
So we're continuing this matter for not 7 days, for 10 days. We're continuing it on March 16th at 2:15. That's a Monday. If Mr. Cripps is available, he should either be here live or at least by Zoom. In the meantime, it would be in your best interest to talk to legal aid. Mr. Smith, anything further we need to do here?
Nothing, Your Honor. Thank you.
All right, thank you. All right, Miss Miller, you're good to go. Elliot Berlin is here on behalf of Copper Bay.
Good afternoon, Your Honor.
Afternoon, just a minute, let me make my note here. Rent here is substantial. It's $1,945 per month, I believe. Mr. Berlin, what's the current arrearage?
Yes, the current rent to retain possession would be $1,436.80. Other money due for pet fees and utilities, $338.70, and our court costs are $310.40. So the total is $2,085.90.
That's through March?
That's correct.
So they must have paid something. At the time of filing, it was 1945, and that was through February. So it looks like some payments have been made. Mr. Eby or Miss Simmons, who's going to speak for the two of you?
I can.
All right, Miss Simmons, what's the circumstance?
The beginning of the year, my insurance company switched, and I was unaware of all that was going to entail. I have several health issues. The Humana took out $400 out of my Social Security that I wasn't aware of that they were going to do. I have medicine, I have doctor bills. It's just been a tough beginning of the year.
Well, you made some payment apparently in February.
Yes.
what's your plan? Do you have a plan to try to catch up the rent?
Yes,
I have my tax return coming.
Yeah, this is tax return time and our landlord tenant cases go down. And our probation fines and cost payment goes up. The law requires that we adjourn this matter at least 7 days. So the good news is we'll still be in the month of March. But next Friday is the 13th, which is quite full. But I could set this for 10:30 next Friday morning, March 13th. Does that work for you, Mr. Berlin?
Yes.
Now, the law requires that I adjourn this matter 7 days at least. So we'll bump this back to next Friday. If they get what they ask for, you'd have 10 additional days to pay the rent or be subject to being evicted, which would be March 23rd. So I don't know if you filed your taxes. I'm trying to file mine, but I don't have all my stuff yet to file it. Have you filed for your refund? I can't hear you.
Not yet.
Oh, well, they can agree to work with you, get caught up in this, but we're gonna address it further next week. I don't expect this to go up any. We are gonna jump from March to April into the next month. But at some point, April rent will be due also. And so you need to get on that. And
Right.
because I don't know how long it's gonna take for the refunds to come back. They could agree to wait for this, but they don't have to. As
We've,
I said, this is among the highest rent in the county. But we'll revisit this next Friday.
I've
Do
spoken
you
to
have
our
a plan
property.
B? I'm sorry, go ahead.
I've spoken to our property manager. Her name
Mm-hmm.
is Brenda. And she agreed. I told her by April that we would be all caught up. And she agreed to work with us.
All right, well, they can do that. Mr. Berlin may not be aware of what his on-site manager is doing, so they'll have a chance to discuss this between now and next Friday. But we'll revisit this next Friday morning, March 13th at 10:30. Is that agreeable with you?
Yes.
All right,
Yes.
I'll see you then. You did a good job. You logged in on time. You got your names on there. I can hear you both. I can see you both. So let's do this again next Friday morning at 10:30 and we'll see what our circumstance is. All right, I'll see you then and get on your tax refund. Thank you.
Thank you, Your Honor.
All right, Mr. Berlin, I'll see you next week.
Thanks.
Mr. Mann, can you hear me?
Yes, Your Honor.
Very good. Well, you're here in the case of Block 14 versus Paul Mann. Mr. Jeremy Gump is here on behalf of Block 14. And they want you to move. They filed what's called a termination of tenancy. Let me make a note here. You are a tenant subject to a case called a termination of tenancy case. And as such, you have a right to hire a lawyer. If you can't afford an attorney, legal aid attorney is here and they may be able to assist you, or you could seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or file the demand in writing within 5 days and pay the $50 jury demand fee. If you're a landlord, that doesn't apply. You may be able to reach an agreement with the landlord by going through local community dispute resolution mediation. That's never happened, but maybe it will someday. Or you may be able to reach an agreement with the landlord, perhaps to move voluntarily, which they could submit what's called a conditional order of dismissal. According to the pleadings, your lease expired in December or November. They served a notice to quit on you on December 29th, asking you to vacate by, they served it on 12/29 for you to vacate by 1/29. You did not vacate, so they filed this action. What's your position?
I never received a notice to vacate the property. I mean, I was aware that I'm on a month-to-month lease, and I'm just behind right now.
Well, they're not asking you to pay the rent, they're asking you to move. I'll talk about that in a minute. The notice to quit was sent by first-class mail to your address. 2.5 West Street. And that's what's required. You knew they wanted you to move. And so they could agree to accept rent, but they're not asking for rent. They're asking to terminate the tenancy. Now, once you move out, they could sue you for back rent. They also can apply the security deposit to back rent. But at this point, it's just a termination of tenancy case. Now, the law requires I adjourn this matter at least 7 days. Mr. Gump, can you tell me when rent was last paid?
Oh, that's a good question as to when it was last paid. I know at the moment the amount due is $2,611.45.
Now, that's called a non-payment of rent case. If they filed it and asked you to pay the rent, you'd have 10 days to pay the rent or be subject to being evicted. In this case, they're not asking you to pay the rent. They're simply asking you to move. And they filed this termination of tenancy. So we're going to continue this for 7 days, which is next Friday. We're going to continue it to 3/13 at 10:45. Let's make it 10:40. Mr. Gump, does that work for you?
Yes, Your Honor.
Mr. Mann, does that work for you?
Right now it does.
All right. Now, if they get what they ask for, you would have 10 days from March 13th to vacate or be subject to being evicted, which would be March 23rd. Now, they're the landlord. They have a lot of discretion in this matter. I guess they could agree if you showed up with $2,700 and paid all your rent to execute a new lease. But I think at this point, they've just decided that they'd rather start over again. They have a waiting list. They have people ready and willing to rent this apartment. Everybody has a waiting list. Who do you communicate with? Is there a manager on site?
Yeah, Larry.
Larry.
All right. Well, you can talk to them or talk to the company, but at this point, we're going to revisit this next Friday at 10:40, and they're asking you to move out. Maybe they'll change their position. Maybe you got a tax refund coming or you're going to pay this. But at this point, it's $650 per month. It's about 3 or 4 months behind. So I'll leave that to you. What you want to do. It might be best to use your money to pay security deposit, first month rent somewhere else. but, we will address this 7 days from now, March 13th at 10:40 a.m. You also did a good job logging in. You were on time, and I appreciate it. I'll see you next week.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Next up is Fenrick versus Webb. Mr. Williamson, are you on that case?
I am, Your Honor. Thank you.
We were here last week. A young attorney I hadn't met before, Tanya Carrido, I think it was. Can't read my own writing. We had some confusion. The defendant had a lease. He didn't know what it was. He supposedly did. In the meantime, you filed a notarized affidavit of Tyler Lego, setting forth the reasons why the plaintiff wishes to terminate the tenancy.
Yes, Your Honor. I apologize. We didn't have sufficient information the first time around.
Mr. Webb isn't here. This matter's set for 1:40, which is right on the tick right now. Let me remove Mr. Mann. He said he thought he would move. Plans to move, but he's out of work. Miss Rarick, Finnerman Rarick, is he still there?
Yes, he is, Your Honor.
Now, this is one of the properties you bought, as you're expanding your enterprise. This is over on Lakeview Street in Sturgis, is that correct?
Yes.
And did he come with the property?
He did not. We redid his unit and filled it with him.
We've had some previous termination cases where you're trying to get people out of this. I guess you're doing the units one at a time. Well, let's see if he's here. I'm looking for Curtis Webb. First. All right, thanks. But he isn't here live. 1 out of 95 times I don't call to find out if they're here, and then they are here, but he isn't here. It's 1:42. Yeah, you told me that last week, Ms. Finnerman, that he came in after you bought it.
Yeah.
So that is what you said. I don't know whether he has a copy of, was served by Bruce Morse. The defendant was personally served with the affidavit of Tyler Lego. But the allegations are he's making threats to the neighbors. He's gonna beat people up. He's in a gang. And
We also served Mr. Webb with the amended complaint with all of the attachments, Your Honor. He's been personally served with everything. He has a copy of the police report, a copy of the affidavit, a copy of the amended complaint. So he should be fully informed as to the basis for the action.
well, maybe that's why he isn't here. Sergeant Morse of Southwest Michigan Legal Services, if he says they're served, they're served. That was served on 3/5. Have there been any other incidents since that time that you're aware of, Ms. Rarick?
Yeah, after he got served, he started threatening Tyler again.
I'll let this clock tick just a little bit, then I'm gonna default him. I don't think I have an order.
Your Honor, I can submit a judgment if there's by whatever means the court prefers. I can
Email would be fine.
email. Sure.
Here's Samsung. Let's see who this is. Somebody's joined us by Samsung phone. Who am I speaking with?
It's Curtis Webb.
All right, Mr. Webb, you're a little late, but you are
Yeah.
here.
Trying to get through the prompts and all that. Kept resetting.
All right, your landlord has asked you to be evicted. They've moved to terminate your tenancy. We were here on 2/27 and the allegations that they were raised were not clear. In the meantime, they have served a police report, a notarized affidavit, and an amended complaint asking that you vacate the premises. What's your position?
Yeah, I got the paperwork. The way I see it is, if you were to evict me on like no payment of rent, that's one thing, but that little affidavit they submitted, it's all, I mean, the guy that they use is just some guy that lives next door with his mom, and it's a couple of them things are true. We did have a couple altercations, but it's nothing like he says.
Well, they want you to move, so we're gonna have a hearing regarding that. Question is, where do we put it?
Your Honor, for your information, we have also served Mr. Webb with another demand for possession for non-payment of rent. He's approximately 3 months in arrears on the rent. So we will be following up if necessary with another complaint for eviction on an alternate grounds, which is failure to pay rent.
Does that have a hearing date yet?
That one does not. We served him with the demand for possession, I believe within the past week. So we need to wait for the allotted time before we file our new complaint.
Yeah, he served me yesterday or the day before I signed it.
All right, so do you plan to try to pay the rent and get caught up?
Yeah, this is the deal. I told her like a month after moving in here that it just isn't a good fit. It's just the conditions of this place. I'm a CDL driver. I did accept a job once I'm healed up down in Tennessee in about 6 weeks, but it's kind of hard to save up for another place, pay them their rent after just coming up with their deposits and all that. Like I told you last week, we had some situations happen during the holidays where their carport fell on my truck. My wife lost her job. Then I got hurt. I filed 2 lawsuits on the landlord. Then after that, this has been, she's asked, I could go out of my way to show you pictures and videos, and I got recordings of neighbors that they've asked that people would call the police on me, report me for anything. And like I said, I got this one neighbor. Yeah, he didn't like my radio, but the way he approached me was he came out there and asked me to turn down with a butcher knife in his hand. He walks the hallways with knives. I mean, I don't know how you're supposed to walk these hallways. My kids aren't allowed here anymore because the kids go home and tell their parents the things they see in these hallways and on this property, and they're not even allowed here. So I think it's a mutual agreement, you know, that it's not working out, but just, you know, the way I look at it, off the grounds of this guy over here, just a week ago, he pulled a knife on a 7-year-old girl and a woman out here in the parking lot. I could do the same thing and bring a bunch of people in to testify. It's just not worth it. If we just come to an agreement, like I said, I would
All
have
right,
been
well, that's a
gone.
possibility. Meg, it's an interesting concept. They've got a termination of tenancy and a non-payment of rent. If he pays his rent, it's a park forest defense on the termination of tenancy.
Arguably, issuing the demand for possession constituted a waiver because that acted like they were intending to renew the lease. But, yeah, I agree. It's an issue, interesting issue. I'm certainly happy to speak with Mr. Webb.
Well, he's agreeable to some sort of negotiated move-out date. Mr. Williamson and Ms. Rarick, are you willing to speak to in a breakout room if I put everybody in a common space?
I think so, Judge. We'd consider, I think, a conditional order of dismissal with a specified move-out date, but 6 weeks when he's already been 3 months in
Yeah, we're
arrears,
gonna have to
probably
see
not
if
going to
we can.
work.
Ms. Rarick, you've got authority over this. Meg, are you willing to get in on this, or are you gonna stay with me?
I think you might need me for the next one. The
right.
Enchanted Glen case. I am
All
certainly
right,
like.
then I'll put them in the room, and yeah, you're here on Enchanted Glen. So, Mr. Webb, everybody hit the button that says join. I'll be right here. If you can agree on a move-out date, that might be a solution that works for everybody.
Thank you, Judge.
Thank you.
Judge, I think we have reached an agreement for entry of a consent order for conditional dismissal. The condition will be that the defendant shall vacate the premises at 615 North Lakeview, number 202, no later than 12 p.m. on Friday, March 27th, 2026. If the defendant fails to meet the conditions, the action may proceed without notice to the defendant or further process, and we would seek reinstatement and entry of a judgment for possession at that time.
Ms. Finneman Rarick is, I don't know whether I should call you Finneman, Rarick, or both, but
Just Rarick's fine.
Rarick's fine.
Yeah.
And you agree with that?
Yes, I do.
Mr. Webb, you agree you'll vacate by 1 p.m. on 3/27/26?
Yes, sir.
And if you don't, you could be subject to being evicted?
Yes, sir.
All right, you've agreed without counsel to vacate. You do have 3 business days to advise the court you didn't understand or you disagreed with what we actually did before the order actually takes effect, but it isn't going to take effect until the 27th anyway. Mr. Williams, I'd ask you to send me a conditional order of dismissal.
Certainly, Judge.
Let me give you the address. It's on the notice. It's 3B Civil at St. Joseph County, mi.gov.
St. Joseph County, mi.gov.
Yes.
Excellent. We'll have that over in a few moments, Your Honor.
All right, very good. Thank you.
Appreciate your time.
All right, Ms. Rarick, Mr. Webb, thank you. There was some give and take here, but we're going to get this resolved. Now, let me repeat. I'm not ordering at this point that you pay money. When you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. That will trigger the security deposit law. They can't apply the security deposit to any unpaid rent or other damages. And I suspect you're gonna hold up your end of the deal. You're gonna vacate by the 27th. Turn in your keys and give your forwarding address in writing, and then we'll see what happens next. I'm not ordering that you pay any money. If we have a hearing where they ask for money, it will be at a subsequent hearing. People will be under oath and we'll talk about what's what. This is simply an order for possession. All right, Mr. Webb. I expect you to hold up your end and you're good to go.
All right, thank you.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you. All right. Hello, Mr. Mast.
How are you?
Good. I'll be with you in a minute. We got some other business to transact here.
All right.
All right. We're going to go back to the matter of Enchanted Glen versus Roche and Cleveland. Oh, that's too fat. They are here. Kim Snow, the manager, is here. Meg Bauer from Legal Aid is here. She indicated that the defendants have done an intake at Legal Aid. It's been assigned to her. She hasn't yet filed an appearance. And Gary Popovitz is here for the plaintiff. A default judgment entered in this matter. I had to go to the electronic file because I don't have everything I need. That entered on February 13th. There was also a money judgment. Rent to retain possession was $3,269. Court costs were $313.45 for a total judgment for payment of $3,582.45. There was also a money judgment entered. The defendant then filed a motion to set aside the default. That motion was filed on February 20th. She's contending, I guess, good cause and a meritorious defense. Good cause, I didn't exactly understand, but the meritorious defense was somehow the rent calculation is not correct. According to the manager, by their calculations, current rent is $4,362 through March. Ms. Bauer indicated she's had a brief opportunity to discuss this with Mr. Popovitz. Ms. Bauer, are you going to file an appearance in the case?
That's correct, Your Honor. I
Why
can
don't you
place
place
that
your
on the
appearance on the
record.
record?
Attorney Meg Bauer, P84816, appearing on behalf of defendant Mary Cleveland.
Mr. Popovitz, you got notice of this about the same time I did. What's your position here?
Your Honor, excuse me, I always seem to freeze up right as I start talking. I'm sorry about that. Your Honor, Gary Popovitz on behalf of Enchanted Glen in this matter. I believe I received notice of the motion to set aside default. I did not file a response. These are typically low dollar cases for the complex, and I chose not to draft a response in the sense that there might be some question as to the good cause. Meritorious defense, I believe she set forth things. I'm not sure I'm not sure they would flush out at a hearing, but that's to be decided potentially. I also know Michigan courts generally tend to allow or like to have matters heard on the merits rather than default, even in landlord-tenant cases. I can't remember. There were two hearings the morning of that we secured a default in this one, and I can't remember if this was the one where there was some inclination in the court's record that there was involvement by legal aid. Legal aid didn't have recollection of it, and then we ended up taking the default. And that's not to put words in anyone's mouth. I'm just neurotically remembering back to the morning of the hearing here, but I have not filed a response. My anticipation was that if the court found merit in the meritorious defense as stated, then it would decide on its own initiative whether or not the good cause was appropriate under court rule. And we stand prepared either to pursue remedy under the default judgment as entered or to restart this case if the default is set aside. I've advised my client of those issues and have not over lawyered it to say, to get to this point, knowing that one of two things are going to happen. It's a non-payment case, and it's likely if Ms. Bauer is
Well,
involved, we can work through something.
I think the defendant acknowledges that rent is due, but I think there's a dispute as to how much rent is. She also indicated while we were waiting that she's preparing to vacate. They're getting stuff ready to move out. But perhaps the most straightforward way to deal with this is to grant the motion to set aside the default and set it for further proceeding. So let's pick our next date. I can continue this till next Friday at 11 a.m.
I would be available for that. I have a hearing in the afternoon, but I wouldn't anticipate this hearing would be long enough. Plus that keeps things moving. So that would be, so Your Honor, if you set aside the default, then we treat today as the first eviction hearing. Theoretically, she can get the advices and those rights and remedies available from legal aid or Ms. Bauer. And then the Friday would be the contested hearing, correct?
Could be, yes. I've got an hour blocked out for it. Miss Cleveland and Mr. Roche, you are tenants in a landlord-tenant proceeding. As such, you have a right to hire a lawyer. If you can't afford an attorney, you could seek guidance from legal aid, and legal aid has filed an appearance on your behalf. You have a right to demand a jury trial. If you do that, you have to do within 5 days and file the written demand. And pay the $50 jury demand fee unless the judge waives it for your inability to pay. You have the right to have the case heard here in St. Joseph County where the property is located. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, Neighborhood Inc., Community Action Agency, or if you're a veteran, you may be eligible for those benefits. We sent that information to you with the original summons packet. You may be able to reach an agreement with the landlord by going through mediation. That is a possibility. It's never happened, but it might. However, the next one is a possibility. You may be able to reach an agreement with the landlord by going through a conditional order of dismissal. That's what we did in the last case. The tenant agreed to vacate by a certain date. It is not in dispute that you owe rent. The amount that rent is what's in dispute. And you contend that there were some recalculations or other things that should have been done. I don't know. The pleadings contend. I don't have the whole file. Let me go back to it.
Judge, may I step in?
Just a sec.
And fill that number in for you.
All right, go ahead. Maybe that'll save me some time.
The pleadings contend that the rental rate is $1,083 a month, and that rent had not been paid, but that rent was paid through November. The defense believes it's actually possible there may not be any rent due based on the rental recertification rate that the tenants were supposed to have. What makes this a tricky case is that Keystone Place is involved. I believe, based on my review of the documents, that the tenant's rent is actually, well, I'm sorry, I have it on a different page here. $224 a month, and that the landlord has been receiving over $1,000 a month since the tenants moved in. I don't want to get too into the weeds here on the details and where that all comes from. Attorney Popovits and I had a very brief conversation about that. But if that's true, then there would be a significant credit on the account, but also the number that we got today just now, the difference between the judgment that was entered in February, $3,582, And the number we just got, 4,362, is only $790 difference, not 1,080. I'm sorry, I've now forgotten that number, 1,083. So that already speaks to a question about how rent has been calculated. I also have a request to extend, if this is going to be the evidentiary hearing, a request to extend it, not or adjourn it from this Friday. The defendant asked the plaintiff for copies of her tenant file back in February, and that request was denied based on her not being an attorney, but an attorney is not required to request the tenant file. That's going to have some of the information that we need here.
Well, let's go ahead and set it for March 13th. If we're gonna have a contested case, we always seem to get contested cases from Enchanted Glen. But you and Mr. Popovich have got a good history of trying to work through these issues. So let's set it for next week.
As an in-person trial, Judge?
No, as a second hearing, let's see where we are.
Okay.
Maybe you can agree on what the amount of rent is. I'm also tempted to do an escrow order. But if you're correct, that the rent should be calculated at 200 and something, and they've been collecting 1,000 and something, there may not be any rent due. So I'm not inclined with that knowledge to do an escrow order. But this devil is in the details. Keystone's involved, there's recertification requirements, there's federal housing guidelines. So there's a lot to do, but as Mr. Popovich said, I'd like to keep the case moving. And let's see where we are next Friday at 11. I'm not going to make everybody come here live. We'll do it by Zoom.
Yeah, you're stuck with me all day, Judge, so.
All right. So I've signed the order granting the motion to set aside the default, set further hearing for 3/13 at 11 a.m.
Great. Your Honor, I do want to apologize to first my client Kim, and then the rest of certainly Your Honor, and then Meg for logging on a couple of minutes after the time I was tied up with something, ending that call and then jumping on. I apologize, especially if Kim was asked a rental amount, and thanks Kim for providing that to the court and everyone for review, but certainly we'll get the
Well,
file.
I just assumed maybe you were stuck at another court.
I appreciate that.
We sat here and stared off into space for a few minutes, and then some other parties came back and we readdressed it. But anyway, I'll see you next Friday at 11 a.m.
Sounds
Gary,
good.
I
Meg,
did
Ms. Bauer, I'll get that tenant file over to you.
Appreciate that. Gary, I did make a point to not discuss the substance of the matter while you were not here.
I just asked what the arrearage was claimed to be as of this date, but no, we didn't get into any of the details.
Well, and I appreciate that. That really wasn't what I was insinuating. I was more, I'm sorry to have Kim be on the spot there without me on a screen, but I trust and I appreciate everyone involved. So thank you so much, and we'll see you next week.
All right, thank you.
All right, thank you.
Ms. Cleveland, you're good to go for now. We'll talk later.
Okay, thank you.
We're going to return to the matter of Patricia Ahrens on behalf of Carol J. Hines versus any and all occupants at River Lake Drive. Dean Hines is present, and the tenant, Timothy Mast, is present, and Andrew Horn is present. We learned last time that Mr. Mast is in the premises. He did not have a lease, but at some point, Mr. Hines executed some sort of lease, not sure when it was. Mr. Mast did not want to move. Miss Ahrens is the guardian for her mother, Carol Hines, and she's been directed by the court to sell this property and use the money to pay for her mother's care. In addition, she indicated that each month that they stay in possession of the property, because of the reverse mortgage that's in place, it costs them $1,070. So there's some urgency on the plaintiff's part to get the property vacated. I know Mr. Mast. We'd worked on a case for a long time, got to know him pretty well. I've known Mr. Hines for a number of years as well. So we talked about this last time, and I guess, Mr. Horn, you agree with my recitation of where we were last week?
Yes, Your Honor.
Mr. Mast, what's your position?
I have found myself another place. Currently waiting on it to be finished because they're remodeling it right now. But as soon as that is taken care of, I will be moving out here. I don't want to any more harm than our house because we had no idea that was the case at all. If that was, I'd have probably been out here a while ago. I was only here to try and help take care of the place, keep it up to date and whatnot, so it wasn't just falling into shambles with no one taking care of it.
I understand. Now, when you and I were working together, was this where you were living at that time?
Yes, I actually did when I lost my apartment, when that was condemned over in White Pigeon. This is exactly where I moved to.
All right. My recollection was you were out at Portage Lake. All right. Well, this isn't any good guy or bad guy. Miss Aarons has the unpleasant job of trying to deal with her mother's estate, which often can cause discord. Mr. Hines, if the property is in fact sold, if your mother were deceased, you'd be one of the beneficiaries of the sale of the home, but she's not. So it's her house. The court directed the guardian to sell it. Mr. Mast, how soon do you think you can vacate?
I'm not sure yet. Last I heard, I think it was like a week ago. It would be like a week or two before the place is available, but I'd have to reach out.
Medicare thinks you're a tenant. In fact, you are a tenant. If you're paying her light bill and heat bill and other utilities, that's inured as income to her, and it makes her ineligible for Medicaid. So it's even worse than we thought.
Yes.
So I'm going to go with a statutory 10 days. Mr. Horn, I don't think I have an order.
No, Your Honor, I can prepare that and send that right over.
The sooner you're out of there, the sooner they can attempt the sale, and perhaps it may alter her Medicare status. Right now, she's in a tough spot. 10 days from today is March 23rd. That's the date for the writ and the appeal. Mr. Horn will send me a judgment. So you have 10 days. Now, if you can't vacate by the 23rd of March, that's a Monday, Miss Aarons, if he's got a moving van backed up there on the 24th or 25th, it's not worth going through an eviction. But you want to definitely get him out of there by the end of the month, because then there's another month that she's not eligible for Medicare. Theoretically, when you move, you're supposed to turn in your keys and give your forwarding address in writing within 4 days of your moving. Mr. Hines, do you have any input on this?
I do, Your Honor. We've had attorneys, and my mother consulted an attorney back in 2023 due to the behavior of the plaintiff. She consulted with them. I was not in the room. I don't know exactly what was discussed, but they did tell me after they came out that there were problems and she was not happy with the situation. This has developed into this. And when I think the plaintiff mentioned something about Medicaid fraud, These attorneys might be looking back to see what past practice was with rent and the income.
Well, I don't know anything about that. This simply has to do with possession of this house.
Correct. And
And,
I understood that, and they informed me of that before I ever came to court, sir.
all right, well, as I said, I get these about once a month. Anyway, Mr. Horn, if you'd send me an order, I'll execute it. Mr. Mast, how are you doing? You look pretty good.
I'm doing actually fantastic, to be completely
You were
honest.
working construction. What are you doing these days?
I work for the people directly across the street now doing construction. I was actually working across the street at the corner of Silver and Michigan Ave today on the house that's going up there.
All right, well, I hope you're doing all right, but you got to get out of this house. All right,
Understandable.
Mr. Horn
I do
will
have a
send me an
question.
order. Yes.
Your Honor, one quick question, not to extend this. So I don't know if Mr. Hines has any personal property at the property. But if that's the case, we just ask that that be removed during the period as well.
I can
It
comment.
is any and all occupants. Mr. Hines, you have stuff in there?
I just have a few items. Most of my stuff is out of there. I had that blue Cadillac pulled out today because the fuel pump was out of that, but Bowers came and got that at 11 o'clock this morning. That is out of there. And I do want to thank you for working with Mr. Mast. I can't even put words to that, sir.
Good. All right, everybody. Hope this works out. Miss Aaron's, you got more heavy lifting to do here, but good luck to you.
Thank
Mr.
you.
Horn,
Thank
thank
you,
you.
Your Honor.
Thank you, Your Honor.
Judge, I think the defendant has a question here.
Oh, Tim, did you have a question?
Yeah, so I had previously acquired a storm door for the back porch because that was broken into in the past. Am I allowed to leave that here for Patty to replace?
No, if you replaced it, it's a fixture. You need to leave it on.
No,
If
I
you
have not
bought
replaced it yet. I haven't replaced it yet. I've only acquired it at this point. I was told not to put it on yet,
All right,
but I
well,
was
that's
asking
up
if
to,
I can
that's
leave
up
it.
to you. You can leave it there, certainly.
Yeah, that door needs replaced bad, so yeah, I'd like to leave it here. It's an expensive door. It would go along with everything else that's here too, all the Anderson windows and whatnot.
All right. Very good. Thank you. You're all free to go.
Thank you.
All righty, thank you.
Thank you, Your
You have a
Honor.
wonderful rest of your day, Your Honor.